Is there more to midlife than just getting through it? Absolutely. Welcome. I'm your host, Debbie Cunningham, jazz artist turned midlife mentor, and I'm here to say to you loud and clear, it's time for your midlife crescendo. Well, hey friend, it is the middle of August, so welcome back. It's hot here in Middle Tennessee, and it's back to school. We talked about that last week in my Open Letter to Moms Back to School edition. That's episode number 31. So if you want to listen to that, you can certainly go back and listen. I wrote a letter for all moms, but then I also specified kindergarten moms, high school senior moms, and moms sending kids off to college. So if you want to go back and listen to that, it was just my heart from my experience to encourage moms through all the emotions and the things they're going through, and also to give you a little insight in what your kids are going through as they process this year. But go ahead and listen to that, and then I encourage you just to enjoy every minute with them that you can. Every moment won't be fun. There will be a lot of emotions, but they are learning and growing, spreading their wings to fly. And so I encourage you to just be present and enjoy your time with them. Now, today on the podcast, we are talking about the importance of wills and other important documents that you need to have. Now, listen, I'm going to say you may actually want to have a pen and paper and take some notes on this episode. Darryl Cunningham is the lawyer that I have on the podcast today, and he is going to explain why you need a will, what happens when you don't have a will. Also, if you're divorced and some of the different things that you may need to think about that perhaps you haven't, so that your ex doesn't get the stuff that you want to leave to your kids. So please pull up a chair, get out a pen and paper, and write some notes on this episode. A little bit longer than normal, about 40 minutes, but I think you'll find all the information he shares very applicable and helpful in your midlife journey. So here's my conversation with Darryl. Well, hey, everybody. Today on the podcast, I have joining me Darryl Cunningham. Darryl is an esteemed attorney and adjunct professor with over 30 years practice in family law and criminal defense, including extensive jury trial experience. He earned his Bachelor of Science in Education from Shippensburg University and his law degree from Penn State Dickinson Law School. He has taught family law and American jurisprudence in a paralegal program and has been involved in various community activities in Pennsylvania. He also served as an adjunct professor at the College of William and Mary in Williamsburg, Virginia. During his time in Virginia, he managed or supervised nearly 3,000 cases for low-income clients with over 800 involving domestic violence. Admitted to practice in Pennsylvania since 1988 and Virginia since 2008, Attorney Cunningham is also authorized to practice in federal courts. His dedication to his clients has earned him numerous awards for leadership, integrity, and selfless service. Outside of his professional life, Darryl cherishes his roles as husband, father, and grandfather. And now I'll add one more detail to his esteemed bio. Darryl also happens to be my brother-in-law, and I've known him for more than 40 years. I'm happy to have him share his wisdom and insight on the podcast today. Welcome, Darryl.
Thank you. And it has been more than 40
I know, isn't that
years.
crazy?
Hard to believe. It's hard to believe.
But yeah, it's surprising that it's been over 40 years. I personally don't feel old enough to have known you for over 40 years. But I'm well beyond that, unfortunately. Or fortunately, right? Fortunately, we have another day to breathe. Well, the first question I always ask my guests is, can you tell us something about yourself that is not on your bio? Maybe even something that I don't know.
You might know, well, some of it. Well, a lot of people know I'm a huge fan of the band Chicago. Have been since I was about 10.
Yeah.
And my wife's ringtone, I made a ringtone for my wife out of the song Just You and Me. And that when she calls, I get to hear Chicago.
Oh, I love that.
And And if my daughter remembers when she was little, I used to wake her up. I used to sing their song, Wake Up Sunshine, to her to get her to get out of bed.
Oh, that's so sweet. I'll have to ask Danielle about that. That's so precious. Well, and probably all the years you listened to Chicago made your brother a Chicago fan, which in turn made me a Chicago fan.
There you go.
And now our son is also a huge Chicago fan. Oh,
It's generational. It's a good
it
thing.
is generational. We still listen and love that music on a regular basis. So that's some good music, good horns, good lyric writing. We like it.
Yep.
Well, today I've asked you here to talk to us about the importance of wills for midlife women, whether they are single or married. I'm surprised, Darryl, as I've talked to women my age, how many of them don't have a will. So, can you tell us why it's important to have a will, first of all, and at what age someone should have a will?
Sure. The age, I'll tell you when I did my first one. My daughter was born 3 weeks before I turned 30. When I came back to the office from the hospital the first day, my boss called me into his office and said, "You have responsibilities now. You may not leave the building. You can't go to lunch. You can't go to visit at the hospital. You can't go see the baby until I see a draft of your will."
Wow.
So it's that important.
But not even
So
just if you have a family, because single
right,
women also still need a will.
sure. I mean, it's very, very important, and we can talk more about what happens if you don't have one.
Hmm.
But it's your life, your things, the things that you've accumulated during your life, and you get to decide what happens to those when you pass. And there are rules that states have, but that may send stuff to people that you really don't want to have your things, or to collect the money that you've earned or the retirement benefits that you've earned. So it's very important. It makes it much easier for the family if there's a will that says this is what's going to happen also.
Yes, and I can actually attest to that through experience, that from different people in our family who haven't had a will, just the difficulty on the family and whoever's handling your affairs to not have a will, how difficult that is just to plow through and get things where they need to go. But also, many of the women who listen to the podcast are also entrepreneurs and business owners. And this is so vitally important to have a will so that there's somebody there to start managing that part of your life when you pass. So,
Yeah, business professionalism is a very important thing, and it can destroy well planned and well run businesses if suddenly everybody's fighting over who's going to be in charge and
exactly.
who's paying the bills, who's collecting the money, and
Yes. Well, why don't we just launch right into that question? Can you tell us what happens when you do not have a will?
virtually every state has what they call an intestacy program. If you don't have a will, they call you intestate. Um,
Okay.
so your will is called the last will and testament. So the testate would be the not intestate would be not having. So they have a pecking order of who gets your stuff. For instance, if you're married, your spouse is normally the person that those go to. If you're not married, they look for children, then your parents, and then you could be, depending on how much family you have, you could be getting cousins and aunts and uncles who you haven't spoken to in years, who suddenly are entitled to be the beneficiaries of your will.
Mm.
People who you don't like may get your stuff. And that's a problem. I have a lot of clients who will come in, and when they talk about doing wills, they say, "My child, my uncle, my parent, we've been estranged, and I really don't want them to get anything." And if you don't have a will, it very well may end up in their lap,
Mm.
and it's clearly what you don't want. The other thing that happens is people say, "Well, I don't have anything," particularly younger people.
Right.
"I don't have anything." Well, you probably do. If you've been working, you maybe have some retirement money, you have a bank account, you have a car, you may have whatever. But if you're in an accident and you pass, there may be a wrongful death claim, which could be worth a significant amount of money to your survivors for the loss of you.
Hmm.
And your will dictate where those proceeds go often. It's not a hard thing to do to get to will, but the consequences to those left behind can be very significant.
Yes, and I think that there's just a lot of confusion when anyone dies, right? But I think a lot of people are afraid to talk about death. They're taught what I've heard is I don't want to draw up a will because I feel like I'm afraid as soon as I do that, then I'm going to die. So there's a
Yep.
lot of fears around wills, drawing up wills.
I heard that a lot when I was in Virginia. We had a contract. I went around to several senior centers and talking to a lot of wills for them. And they would say, oh, as soon as you draw up a will, you die. And I said, well, I got my first one when I was 29. It's possibly the slowest death in history.
So true.
So, and I will say one thing that enticed some of the older ladies, and there was primarily older ladies in those groups, to do them is they would say, well, I want to give it to my granddaughter, but she's with this guy, and if she marries him, I said, well, you can put in a trust provision that she gets it when she's 35, provided that. And they like the idea of that kind of control.
Right.
And you can, we all have family members who you look at and you go, gee, if I give you $10,000, it's going to be gone tomorrow.
Mm-hmm.
I did a will for a lady whose parents were killed in an accident, and her brother was going to college. I think he just finished his second year of college. So he got like $90,000. And this is 20 years ago. So he bought a Corvette, paid the insurance for a year, paid his tuition to go to school, and was the most popular guy on campus for a year. And then had to take a year off of college and work because he spent all the money, didn't have the money to go back to college. So you can put in provisions that say, oh, we're going to put this money in trust and somebody else can decide what kind of car. So when he comes and says, gee, Debbie, I need a car, you can say, yes, you do, but you don't need the $80,000 Corvette. You need a $20,000 used Volkswagen.
Right, exactly.
And then you can pay the tuition and control the money until they're old enough to understand what's going on.
Well, I think what's great about it too is we have to remember that what a will does is it gives us an element of control and an organization of where things go, to whom, and in what manner. Like you said, you can set it up as a trust to get at a certain age or at a certain time. So I think that's really, really important. Now, in addition to general wills, can you talk a little bit about the importance of powers of attorney and power of attorney forms and living wills?
Sure. We usually ask people to do all three. Sometimes they don't want to.
Mm-hmm.
But we actually discount our prices for them if they do all three because we get them. They come in once, we get all the information, we get it done, and then they're good to go until less changes are needed. Because we really do want them to be protected. So we'll start with the power of attorney. The power of attorney gives someone the ability to work on your behalf. And you can control, again, when that happens. Can they do it only when doctors say I'm not able to do it on my own? Or can they do it now for me if I need them to do it? So you could do a power of attorney, make one of your children your power of attorney, and they could go pay your bills. They could apply for government benefits for you. They could, sue somebody, sell your for for you, and do whatever. You can make them as broad as you want or as narrow as you want. I can give you a power of attorney that says, Debbie can go to my bank on Wednesday, August the 14th and withdraw $25 from my account ending in 1234.
Wow. Okay.
That's okay. Or you can say, you can control my finances. You can do investments for me. You can run my business for me. You can do anything that I can do on my behalf.
Okay.
You can make them time limited. So if you're going to go away for 6 months, somebody can run your stuff between date A and date B. And the nice thing about it is, if they do it legally, they can only do what's in your benefit. They can't pay their own electric bill. They can't buy a car with your money, those types of things.
Right. Now, what about living wills?
Okay. Living will also, it goes by a number of names: advanced medical directive, health power of attorney, living will. What that does is it gives someone the ability to make medical decisions for you if you can't. That's important to get past people. If you can't.
Right.
So if you're in the hospital, if you fall and break your leg and you go to the hospital and they say, gee, do you want to set your leg or, we can amputate it. Your kid's not going to say, oh, go ahead and amputate the leg if you're sitting there and you're fine. They're going to ask you. What happens is if they have you under anesthesia, you're in an accident, you're comatose, or for whatever reason you're on drugs that don't help your thought processes, then they'll look for the person who has the authority to make that decision for you. Normally we do it with our spouse, but I don't know if you remember when my dad was going to the hospital, I
Yes.
got one of those for him. And my mom said, don't make me the person to make the decision because he will be on the machine forever because I will never be able to say stop it.
Mm.
And that's important to know.
Yes.
So people who will follow your instructions
Right.
should be the people who you name to follow your instructions. And you make very clear instructions and you can tell them, you must follow my instructions or it's guidance and you can use your own judgment. I usually like to follow instructions because that makes it easier when people walk out and say, here's what they did. And mom or dad said, we have to do this. So that's just the general, they can get you a new doctor. They can, if they don't like what's being, the nursing home you're in, they can switch you from one place to another. They can control what's going on until you can do it yourself.
Right.
And then the second part of that is the living will piece, which is if I'm terminal, and that we really have to make clear with people that if you say, I don't want to be resuscitated and you go in to get your appendix taken out for some reason, your heart stops, you're not terminal. They should do CPR. They should hit you with the paddles and bring you back, But the living will part is if I'm terminal, and we always write that way, if and only if you have cancer, you have, you're comatose, you're vegetative, you're not going to get better. And my heart stops. One, do you want them to resuscitate you? Okay. Do you want to have blood products? Do you want to have hydration? Do you want to have tube feedings? Do you want to have surgery? Are you okay with chemotherapy if you're going to pass anyway?
Right.
And everybody's allowed to make that decision for themselves. And you're telling them, this is what I want you to do. So you can say, I want nothing other than you can give me drugs that make me comfortable so I don't have pain. And some of those will suppress your breathing and you may pass more quickly, but that's your choice and you're telling them what to do for you. I've run into some objections to people who say it's not really a living will, it's a killing will because you're telling them how to kill you. I'm going, it's your choice. You can say, do everything possible to keep me alive.
Yes.
But you're telling everybody what to do and it makes it easy. I mean, you and I were present when my father passed and there were 30 some odd people in the waiting room.
Yes.
And the doctor told my sister and I what was going on. And we walked in and said, this is what he said we're supposed to do. So this is what we're going to do. And there wasn't nobody was happy that he was going to pass. But by the same token, they knew it's what he said to do.
Right.
So it made it much easier. There was no fighting. There was no, I'm taking you to court to stop this.
Right.
It's it can be a really bad situation because it's highly emotional and it's charged and people don't want anybody to pass if they can help it. But you should get to make your own choice that way.
Absolutely. And I think that that's what I'm trying to share with people to help them understand what that does is having these POA forms is really helps you to have control over you're getting to choose how you want things to go and also
Right.
take the choice away from people who are in an emotional state, your children and your family members who are feeling emotional anyway because something's wrong with you or you're going to pass. And then that isn't on their shoulders. And, you get to choose that for yourself.
And the person who has to make that choice can show them in black and white where mom or dad or Uncle Bob said, this is what I want to have happen.
Exactly. So everybody's on the same page. Now, privacy laws have continued to change through the years, and many midlife women have children going off to college. So I'm going to pivot just for a second. They don't
Okay.
always realize the importance of these POA, medical POA forms for the college student. Can you elaborate on that a little bit?
Yeah, it's a great idea. And I'm going to be honest with you. I didn't have one when I went to college because they weren't really a
We
thing.
didn't have them.
Um,
We had to have them when our daughter went to college because we couldn't get any access to her medical information when she had to go to the hospital or had to go to a visit. So that's why it's so important.
Yeah, I mean, it's the same when you talk to colleges, if a parent calls and says, gee, I want to know how well my kid's doing because I'm paying the bill, they're not going to tell them
No, they're not.
because they're adults unless they sign a release. So it's the same thing. The advanced medical directives waive HIPAA rights so that the doctor can have a candid conversation with you. They can share whatever information is necessary
Right.
for you to share. Now, remember, they're going to likely share just the information about whatever's going on at the time. So if your student has something in their medical history not pertinent to what's going on, they're unlikely just to tell you.
Right.
So don't think that you're going to call and say, I have this thing and I want to know what's going on, because the student just at that point in time is able to make their own decisions. So, but it's important to be able to call the doctor and say, I'm in Pennsylvania, my kid's in Ohio, and I understand they were in an accident and we're on our way, but we need to know what's going on and we have the health power of attorney. So the HIPAA thing will allow them to, the waiver of HIPAA will allow them to explain it to you so that you can help make decisions.
Yes. And I think some schools actually have a medical release form so that they can give you information, but these forms are really important just to be thinking about, as we're moving forward. Well, tell us a little bit about setting up a will. And I think the unknown of what do I do to set up a will is overwhelming to people. Can you talk a little bit about that, the process?
Sure. It depends on what you want to do, how complicated it is. Most people can do what we would call a simple will, where they say, this is the person who's the executor or the executrix, the person who's in charge of my estate when I pass. They're the ones who has to gather the assets, check for the debts, make sure everything gets done, file the taxes. And then if you're giving everything to your spouse, to say, gee, I leave everything to my spouse, usually we put in a provision that says, provided they survive me by 30 days. And the reason we're doing that is if you're in a car, I'm assuming you go places with your spouse.
Yeah.
If you're in an accident or something, and spouse A dies on Monday and spouse B dies 15 days later, if you don't have those kind of provisions, you may be stuck in a situation where they do one person's estate, pay all the attorney fees and all the taxes and all those things, dump it into the other spouse's estate, pay the attorney fees and the taxes and all those things, and then it goes to your children. So by doing the 30-day wait or 60-day wait, there's nothing magical about 30.
Mm-hmm.
It's just the likelihood is if you survive 30, you'll survive. We just won't the medical people won't guarantee what your health condition will be.
Right.
So we just do that as a precaution to avoid taxes and multiple estate processes. And then they give it to an alternate. And they say, whatever I have, you can give specific bequests, which is I give, child A my car, I give child B my tool collection, whatever it is, funds, whatever it may be, my coin collection. Or they can just say everything else goes, all my stuff, real, personal, or otherwise, goes to. And that's a very simple will.
Mm-hmm.
You can put trust in it, particularly if your children are small, that says, in the event that my child is under the age of, and you get to pick, it can be 25, 18, 45. I had a client whose stepson was in his 40s and still borrowed money every month from his father to pay his bills, despite having a good job. So she put everything in trust to him until he started to receive Social Security, with his youngest sister as his trustee who was controlling any money he was going to get.
Wow.
And you can do that. But you can put trust in to make sure kids can have money to go to school. Like we talked about the guy spending all the money out. I usually suggest to people 25, because that way they get through college, they get a couple years to work, find out how hard it is to make money. And then they get some or all of it. You can space it out. I have them do 10% at 25, 10% at 30.
Right.
And they just keep going down and keep dribbling it out. Or it can be straightforward. Get it all at a certain time. But those are pretty simple. If you have a large estate, a lot of money, you might be looking at more complicated trusts, what they call Q-tip trust and pour-over trust, all those things that I don't like to do, because you're trying to avoid primarily the federal estate taxes. Right now, they changed those back during the Bush administration and the Trump administration. Again, right now, you don't pay federal taxes. I think it's 13.6 million before you have to start paying. And it starts at 18% and works its way up like 30 something. Mm-hmm. It used to be at 650,000, you started paying 28%.
Wow.
So, if you had $1 million,
that's a big chunk that you're having to pay in taxes.
28% of that $350,000 over 650.
Yeah.
So if you have a lot of money, then you can set it up so that trusts happen to try to avoid some of the probate expenses.
Yeah.
Normally, the guys who do that kind of financial planning tell me if you don't have a significant amount of money, if it's not a 7-digit estate, the cost of setting it up may be as much as you would pay in estate taxes anyhow.
Right.
So it can be very complicated, in which case you need to know what accounts you have, how much are in all the accounts, what properties you own, do you have real estate, investment accounts. So you may have to gather a whole lot of information, and it's a long, drawn-out process.
That reminds me of another question I want to ask you, but I'm going to table that one for now. But remind me that I have a question about all the accounts. Okay, so who should have a copy of your will?
I usually tell people, don't give anybody a copy of your will. Just tell them where it's at in case they need it.
Okay.
Your will is a piece of paper until you pass. So you may change it 10 times between now and then. And then what you do by giving somebody a copy of your will, and then you change it and you change what they're getting, or you take them out entirely, you increase the risk that they're going to challenge your estate and say, well, when they did the will giving me everything, they were competent. Right. When they changed it, they were off their gourd, they were drug addled, whatever it may be, they had mental health issues, and therefore this will shouldn't be valid. So if nobody knows what they're getting, it makes it harder it decreases the probability of them having a complaint.
Right.
Now, that's different than the power of attorney and the healthcare directive, because you do have to give copies of those.
Okay.
But the will is not a valid piece of paper until you pass and somebody takes it to the courthouse and probates it.
Okay. And a will normally is it have to be stamped with any kind of legal seal, or do you have to register your will anywhere?
Each state's a little different about that, about what constitutes a valid will. Normally what we do is what they call self-proving wills, which means you come in to sign it. We have two witnesses, normally not beneficiaries to your will, unless it's like spouses doing things, who sign off saying they saw you do it, you were competent when you were there. And usually we did judge competency, but do you understand what you're doing?
Right.
Do you know who your beneficiaries are, and if you're not giving something to them, is there a good reason? And most people have really good reasons when they walk in the door. I haven't seen my kid for 20 years. I'm not giving them anything, kind of thing. I've had those happen a couple of times. But just having conversation, were you aware of what's going on? And there's nobody giving you a competency test. But then what they'll do is they will witness it and it'll be notarized.
Okay.
So you normally don't have to bring somebody back in and say, yes, this is Uncle Bob's will. I saw, I recognize his signature. Some states will allow you, like you can do it in Pennsylvania without the notary, but then somebody has to show up and swear when they go to register or probate the will, that it's your signature and they understand you were competent at the time they did it. So
okay.
Most places, I believe, have gotten away from having you file your wills ahead of time because most courthouses don't have the facilities to hold all those. A lot of law firms will set up places where they will hold original wills for you so that they're not damaging fires, or when you move, they get lost, that kind of thing. Plus, then when you pass, they'll come back and they say, yeah, we did your mom's will, so we can do your state if you want us to. No, they don't have to. You can say, I don't want you to do my state. I want to take it someplace else, and they can't hold your will hostage.
Okay.
But you're really going to keep it somewhere safe, in a safe deposit box, or safe at your house or whatever. You just need to let somebody know where it's at when you pass.
Okay.
A common thing that I have gotten with wills is people want to put their funeral arrangements in their will. This is what I want for my funeral. And I always tell them not to do that, because normally what happens is you die Monday, they do a viewing Wednesday, they bury you Thursday, and somebody opens your will on Friday.
Okay.
So they're not going to know. So I would always tell them I have my will, my original will, and my desires for my funeral and memorial services are in an envelope in my desk drawer. So when I pass, you know where to get it.
Right.
So every now and again, you still have people who insist, even though you tell them that.
Well, what other things do we need to consider when devising a will, and what should prompt consideration to modifying a will?
What you want to put in is you want to make sure that you've covered all the property, which is why they put that catch-all clause that says all the rest and remainder of my estate goes to. But think about who you want it to go to. What happens if that person's not there? So, for instance, in mine, it says everything goes to my wife. And in the event she doesn't survive me, then it goes to my daughter. So we don't have to do two sets of wills and whatever. do you want to give everything to family members? Are you looking to give to your college, to nonprofits that you've been involved in? Where
Churches.
would you like your things to go? Sure. And what do you really have to give away? I've had people come in, I worked at Legal Aid and people didn't have lots of them. They'd say, oh, I want to give $10,000 to my church, but they didn't have $10,000.
Right.
If you put in there that you're going to give $10,000 to your church and you don't have 10,000, they're not getting it.
Mm-hmm.
But you can do a percentage, which I always find makes more sense. So whatever my net estate is after my funeral expenses paid, I want 10% to my church and 10% to my nephew and 50% to my kids. And then if it's $100, they'll divide it out by percentages.
Yeah.
So unless there's something very, very specific, like I'm leaving my grandmother's wedding ring to, I have a classic Mustang or whatever, and that's going to go to.
Mm-hmm.
I always be cautious with those. If you say I'm leaving my Mustang to my kids, and then you sell the Mustang and have another car, they don't necessarily get that car because it's not the Mustang.
Oh, okay.
People say, but it should be my car. I said, then say my car.
Wow, that's important to know. That's an important detail to know, actually.
Yeah, but yeah, you can give specific things to people, but if you're not planning on dying for the next 30 years, are you going to have those things now, or do you just want to be more general?
Right. Well, of course, often people are fearful about the cost of setting up a will. Can you talk a little bit about the costs of that?
Sure. It's going to vary from location to location. Obviously, if you're in Philadelphia or you're in Tennessee and Nashville, it's probably going to be more expensive than if you're in Chambersburg, where I'm at, just because the attorneys tend to charge more money. And it will also be based on, is it a simple will or is it one of those with multiple trusts? And if you're going to draft a 20-page will, you're going to spend more for it. It could go from a couple hundred to thousands of dollars, depending on how much detail and how much how the complications to your estate. If it's a very complex estate, you could spend a lot of money. So it's just one of those ask. And I know people who will do wills very cheaply because it's a way to generate business, to get people into your office.
Mm-hmm.
If you're a small office or a new firm. And then there are firms that have been around for 100 years and they go, yeah, we're charging you $600 to do this simple will because we can.
Well, also, I Googled free wills and POA forms from LegalZoom. What the things that popped up were LegalZoom, Rocket Lawyer, Law Depot, things like that. I found all of those as well as free power of attorney forms on my state government site. So, are any of these sites legit? Can you tell us about using them as a budget option?
Sure. The ones on your state site are probably the most legit because somebody drafted them to follow whatever law
Right.
the state out. The problem with doing them yourself is they're not necessarily written in plain English. And when they start asking you for options and using legal terminology, if you don't understand the legal terminology, you may not be doing what you think you're doing.
Right.
If you want to draft them and then pay somebody, $100 to review them, make sure it's right, that wouldn't be a bad idea. A lot of the ones that you pay for, $99 for a will, they have had somebody look at it and say, yes, it meets our qualifications, but some of them I've seen are not up to date when the state changes the rules
Okay.
about what notices that had to be placed on things, or they just switch out terms or terminology. They may not necessarily be up to date. And what they try to do is draft one that works everywhere, and then they have somebody in each state try to tweak it. And again, it's one of those things, if you don't know what you're doing, you could do more harm than good.
Right.
So can they work? Yes. Are there circumstances and consequences that could come up? Yeah.
Well, I was wondering, so what is the protocol? And I'm asking for general knowledge for everybody. Obviously, we all live in different states who are listening. Can I just call up I have my own lawyer, of course, but can I just call up a lawyer's office and say, I'm trying to get a will set up. Can you tell me how much you charge? I mean, what is the protocol for that?
It happens all the time. People say, a lot of it, they'll say, well, it depends on what you want in it. Say, Fred, give me a range from a very simple will to one that's not as simple. And they should be able to tell you, oh, it's going to be, $200 or $1,000 or whatever it is. If they don't want to give you any kind of a range, call someplace else.
Yes, that's what I was going to say.
It's not that big. I mean, I have a price sheet that I can look at and say, this is about what it's going to cost. But once we get into it, I'll let you know if it's going to be more than the basic.
I think just having a basic will is the biggest thing that's so important. Just in case, again, it's basically an insurance policy that your items, your property, your things that you want to protect are protected by law and go where they need to go. And there's no people fighting over and everything else because you've specified in your will. So a general will, I remember our first will was, we got it when Deanna was born, our daughter was born.
Yep.
And it was, I think it was $100 or $125. So, so it was very simple, obviously. And the big thing then was, where was she going to go? Should something happen to us, who was going to take care of our child? So all of that was spelled out in there, and then our money as well. Are there different considerations in addition to a will if you are divorced or widowed?
Well, one big thing to make sure of, particularly if you're divorced or even widowed, but particularly if you're divorced, is that there are a lot of things that you own that pass by contract. So if you have a retirement account, then you say, I'm leaving it to my husband, Bob Smith, and you don't change that and you pass, Bob may get your retirement account.
Oh, if you're divorced.
Beneficiary, yes.
Wow.
As a matter of fact, a lot of in Virginia and again here in Pennsylvania, when you do divorces, they put a notice on your divorce decree that this doesn't change beneficiaries on life insurance policies, whatever, even though you're getting divorced, because there was a big case back a few years where first wife, second wife were fighting over a rather large, I think it was retirement account, because it just said my wife.
Oh, wow.
And one was the wife when it was written and one was the wife when he passed. So we really want to make certain that I tell people the minute they get divorced, I said, you need to call your retirement people. If you have a life insurance policy, you call and change the beneficiary, check with your bank accounts, your investment accounts, anything that allows you to name somebody to receive the property, and change it, because it's a contract.
Yes.
And it is what it is. And even though you're divorced and your will may say, I'm leaving everything to whomever, the contract may say it goes somewhere else. People overlook that a lot. And if they don't do it right away, it's like anything else. You kind of put it aside.
Forget
and
about
then
it.
6 months from now, you haven't done it either. Yeah. And I'm certain you don't want to pass and have your ex-husband or ex-wife get stuff.
Yeah.
They've already gotten enough from the divorce.
Well, especially if you want it to go to your children or grandchildren, you want to be able to differentiate that.
Right. One of the other things we talked about and kind of scooted was, we talked about what do we give anybody your will. The power of attorney and the advanced medical directive are very different. You do want to give copies of those. The power of attorney, the person who's named as your agent or an alternate agent should each have a copy of either one of those documents. The power of attorney, you should take to your bank and let them know who the power of attorney is and who would have access.
Oh.
A lot of people, banks think they're very important. And I've had them take original power of attorney, scan them, and then shred them. So tell them, here's a copy you can have, here's the real one, so it's a true copy. But they can make a notation in there who has the right to have access to your account information. And the power of attorney is one of those things. Can they do it now, or do you only if you're disabled? Which is kind of bad, because like I said, if you go away on vacation for a month or two, they can't do anything because you're not disabled necessarily. The advanced medical directive, same thing. Your primary care physician should have a copy. Anybody who's enabled to make your decisions should have a copy. If you have specialty doctors, cardiologists, internists, whoever's working on you with things that could cause you harm, should have a copy of it. I suggest that you keep a copy in your glove compartment, or put a card in your wallet with your license that says, I have an advanced medical directive, call these people, and my primary care doctor is.
Wow.
Just, they don't rush you to the hospital. Usually what happens, if ladies carry a purse, if you have a purse and you stick it in your purse, they're going to always pick up your driver's license, your purse and all your personal things, so that you're not in a hospital and somebody has your credit cards and whatever. So they'll look that up to find out who you are. They'll check your registration in the glove compartment. They'll find that and send it along with the ambulance crew. And then they'll know who to call, because the health director, the advanced medical director says, my agent is, my wife, this is her address, this is her phone number, this is her cell phone number. So they can call them and say, they're here. What do you want us to do?
Wow, I hadn't really thought about that actually.
And most hospitals, if you go in for surgery, give them yours because they have their own. And the ones that I've looked at are all very friendly to the hospitals that may not be exactly what you want them to do.
True.
I usually tell people, make a copy. When I draft them, it says an original or a copy is as valid as the original, so that you don't have to tote the original around. You can keep the original with your will and your other important documents, and you can make as many copies as you want. I mean, if you have 10 doctors, make 10 copies and hand them out.
Wow. That's great advice, actually.
And a lot of times the hospital will contact your primary care physician and say, we have your client, your patient so-and-so here because they were in a car accident, and your primary will show up to see you, or at least have the information about what your issues are.
Well, you've definitely given us a lot to think about, and I think it's so important that we consider these things, ladies. Midlife is an important time as we are aging and moving toward the end of our life, no matter when that is. Might not be till we're 100, but we still need to have some of these things in place.
You know what? The other question you asked, you said we wanted to talk about was, why would you change your will or any of the
Yes.
documents? I always suggest to people, anytime something big happens in your life, there's a birth, a death, a marriage, whatever it may be, it's a good time to reconsider. You don't have to go run in and change it if your cousin has a baby and they weren't going to get your belongings
Right.
anyhow. Just think, every time something big happens, or even twice, like when you change the batteries in your smoke detectors, not while you're on the ladder, get off and think, okay, did anything happen now in this 6 months for me to do this? And if so, call and get it changed.
Right.
Sometimes the little changes are way less expensive than a new will. They can do it with what they call a codicil, which is just an addendum to your will. It says paragraph 3 said this, now it's going to read this way. I don't like those a lot. I usually, because with computers, your attorney likely has your will on their computer, and they can just go in and take out paragraph 3, put in the new paragraph 3, and have you sign it. And again, you eliminate but I was supposed to get something under paragraph 3, and Auntie Sue was not in her right mind when she changed it and took it away from me.
Right.
Because they'll never know if you don't show it to them.
Right, exactly. And then when you said that, it made me think of something. When someone dies who is in your will, who happens to be in your will, we have to remember to change that, because what happens if you have someone named in your will and you pass?
It depends on whether you've named alternate, like if they were the
Beneficiary.
executor of your will,
Mhm,
and it says, in the event they can't or won't do it, then so-and-so does it,
mhm.
then you don't have to change it, because if so-and-so is still around. If it says they're going to get my car if they survive me by 30 days and they don't survive me by 30 days, then you just simply move to the next person. If you haven't made those provisions, you may need to go back and change.
Yeah, that's what I was thinking. And then, because it isn't automatic, or let me ask you this. If, let's say, I leave something to my child and then my child passes, unless I've put in my will that then should go to her children, it doesn't go to her children. Is that correct?
Correct.
Yes. So all of that has to be spelled out.
Yeah, and I usually tell people, leave it to your child, not to your child and their spouse, because if they divorce and your child dies, and it says, I'm leaving it to Bob and Sue, and Sue's not there, Bob may still get it depending on how the law reads in your area. But they do have a thing you can put in that you're leaving it to your daughter, or if you have multiple children, in the event that she passes, then it's going to go to your to your grandchildren.
Mhm.
And if they're underage, you want to put it in trust. So that's really what you're looking at. It's what they call, and if they have multiple children, you can say, I leave it to my children. And then what they call per capita with per stirpes representation, which just means count how many children are there when you pass. And if they're not there and they have children, their children, per stirpes is by the branches. It follows the family tree.
Right. So
it'll go to the children, not to the spouse.
yeah. Okay, well, you've given us certainly a lot to think about. Is there any other advice or things that you'd like to share with the listeners in regard to wills or POA forms?
Don't want to sound like a broken record, but they're very important to have. If you can't afford to get them all done at once, get the will first. Get the power of attorney second if you're having health issues, if you're having issues where you may have things to take care of. In the advanced medical directive, toss up between the power of attorney and advanced medical directive / living will, depending on what your health is. If you're healthy, do the power of attorney first, otherwise. But if you can get them all done at once, I would try to get them all done at once and get it over with. And then make sure they're safe and secure to people aren't getting their hands on them when they shouldn't be. Get a cheap safe deposit box, or like I said, a lot of law firms will hold them for you if you want.
Yes. And where can my listeners find you online if they're local and need your law services?
I work at Mooney Law. I work out of the Chambersburg office, but our website is real easy. It's Mooney, MOONEY, the number 4 law.com.
Great.
We have offices all over South Central Pennsylvania.
Great. Well, thank you so much for being our guest today. I appreciate all of your wisdom and advice.
Well, thank you. It's good seeing you.
I know. Well, I hope you found that information helpful and you realize how important it is for you to have at least a simple will to protect you, your assets, and your loved ones, and that the things you do own, even if you don't own a lot, just your car, your house, you might have a bank account, that those things will go to the people you want it to go to when you pass from this world to the next. I pray that you will really put that on your calendar and make it a priority to get that done, because life is short and we never know from one day to the next how things are going to go. Listen, I know from experience in my own family, just the hoops and the stress that your loved ones have to jump through if you do not have a will. It is gut-wrenching and hard enough when someone passes from our life, but it's worse when you have to spend months straining and stressing over paperwork and things that nobody knows where they are, passwords that you can't get into laptops or phones or other things to find documents that you need. It's just excruciating, adding on top of the grief. So I'm really just going to encourage you, ladies, if you're listening, that you make having a will a priority. And if you have one and you haven't updated it for 20 years, you need to go back and look at it and update it, okay? Next week on the podcast, we'll be talking about empty nest, because I know in August a lot of you are sending kids on to college. So we're going to talk about that, the emotions of that, the impact of that, and the possibilities of that for your midlife season. Thanks for tuning in today. And remember, midlife is just a brand new season to find your passion and purpose for your grand finale. Talk next week.